following BLTV program is brought to you by OFlaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin OFlaherty from OFlaherty Law, and today we're going to talk about how debt is divided in Illinois divorce. So when you get divorced, assets and debt in Illinois are divided based on whether they're marital property or non-marital property. So that's the threshold question, whether the debt is marital debt or non-marital debt. Marital debt is generally any debt that was accrued after the marriage, regardless of whose name it was in. Unless in specific circumstances, if it was accrued just for one person's benefit, you can make the argument that it's non-marital debt. But generally, it's anything that was accrued after the start of the marriage. Anything accrued before the start of the marriage that's in just one of the parties' names is typically non-marital debt. So that's pretty simple. So we're talking about dividing up marital debt. So how is marital debt divided? There's two types of states in the union. There are 50-50 states that just divide everything evenly, and equitable distribution states that basically weigh a number of factors to determine what's fair in dividing up the debt. So it's not necessarily going to be 50-50. Illinois is an equitable distribution state. So that means courts weigh a number of factors like the needs of each spouse, the length of the marriage, which assets and other awards like maintenance that the spouses are already receiving as part of the marriage, and the nature of the purchases involved. So, one thing to consider is if one of the spouses is receiving the family home, they're more likely to be responsible for paying the mortgage. If the purchase that led to the debt was greatly to the benefit of one spouse and had really nothing to do with the other, they're more likely to receive the full burden of that debt. The final thing to remember is that regardless of how courts allocate the debt, the spouses are both responsible still to the creditor. So the bottom line is if you are jointly on a credit card and the court says, husband, you're going to be responsible for these credit card payments, and the husband stops paying, the creditor can still go after the wife. The court can't change the creditor's rights to collect. So even though the court may allocate the debt to one person or the other, if the person that it's allocated to fails to pay it, then the other person is going to still be responsible to the creditor. So that's why it's a really good idea to, if you can, pay off as much of the marital debt with marital assets as possible, either in the course of the divorce or before the divorce. Otherwise, if one person fails to pay, then there are some remedies like contempt proceedings to try to get them to comply with the court's order to pay their share of the debt. So if you have any questions, please leave them in our comments section below the post on our website, learn-about-law.com, or on the YouTube video associated with this. Please subscribe to us on YouTube, SoundCloud, and iTunes. Feel free to give us a call for an initial consultation at 630-324-6666. We have a heavy practice in family law, but we also practice nearly every other area of law. And we have 6 office locations for the convenience of our clients throughout Chicagoland. So thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.